Yeah, it is done.
Done.
Yeah, शुरू कर दीजिए please.
Kansha, start kar. We are live.
Okay. Am I audible?
Yes, please start.
Good evening, everyone. I welcome everyone to today's session presented by BSK Legal. BSK Legal is one of India's leading law firms having its office at New Delhi. The firm has an all-India presence through its alliance with local councils at different locations from all states and union territories of India. Being a full-service law firm, the firm is capable of providing legal services on all aspects of clients' businesses. The firm's domestic and international clients include leading private and public listed Indian companies, various government-owned undertakings, leading IT companies, banks and financial institutions, insurance companies, multinational companies, and other foreign entities. Today, we have with us two guests. The first guest is Mr. Amber Gupta. Mr. Amber is presently working as a head, legal and company secretary at Aditya Birla Sun Life Insurance Company Limited. Mr. Amber has a rich experience of 20 years in the field of legal compliance and company secretarial functions with a specialization in financial services sector, capital markets, insurance, banking, and NBFC regulations, IPR and IT laws, labor laws, and dispute resolution. Mr. Amber, in his current role, provides legal advisory on key issues relating to corporate laws, fraud and claims, business and operations related issues, transaction advisory, and corporate governance. We also have with us Mr. Sanjay K Chadha, Managing Partner at BSK Legal and also practicing as a Supreme Court lawyer. Today's topic of the webinar is legal jurisprudence and fraud in life insurance. I pass on to Mr. Sanjay K Chadha, sir. Sir, you may begin.
Thank you, Akanksha. And I really welcome you, Amber ji. It's a great honor for all the participants today. We have, we are live streamed on YouTube as well, and where the major rush is there. I once again, from core of my heart, thank you, Mr. Amber Gupta, for taking this, accepting our invitation and coming here and throwing, light on the subject today. Webinar. So tomorrow we will have another session that will be specifically for, more relevant as far as the career in insurance sector is concerned. So today the topic, as we have taken up, is legal jurisprudence, fraud in the life insurance business specifically. I would take 10 minutes and explain to my important listeners who are with us here in this session about why this topic is relevant today, what exactly is there, and then, person who is heading one of the biggest private, I would say, life insurance company, that is Aditya Birla Life Insurance Company. We, as in BSK Legal, we have gotten a privilege of working with them, with the Birla Sun Life, since last more than 12 years. Many of my listeners know that we are, almost all the insurance companies we are catering as of today. But as far as the insurance subject is concerned, I would like to begin with a topic, with the very important aspect of insurance, that is that insurance is part of union list. So only the union has right, or the central government has right to make laws on the insurance subject per se. So just for the sake of information of my listeners, I wanted to say this. Then a very important landmark law. Initially, there was an Insurance Act is there, 1945 Act is, that's earlier Act is already there. But the major, the major turn in the insurance sector took place in the year 1999 by passing of the IRDA Act, through which the insurance sector was deregulated, if I may say so. During the, the 1991 onwards, the government of India has adopted the privatization, liberalization policy. As a part of that, the insurance sector, which was initially limited, we were having only one insurance company, that is LIC. Now, at present, if we see life insurance, there are more than 24 life insurance companies that are existing. So, to be very straightforward, private players were allowed in the sector. And that is the reason we see that many multinational companies have joined hands with Indian counterparts here. And initially, the FDI was 24%, which was increased. And there is another talk is going on that this is going to increase far more now. So private players were involved now in the year 2000 onward. And a great regulatory body is formed. Like for the banks, we have got RBI. For insurance companies, we have got IRDA by virtue of this act only. So as far as the life insurance companies, I said 24 life insurance companies are there. If we take into account the non-life insurance companies also, there are about 34 of them are there at present. And many of them are, it's a tough test now to become an insurance company. A lot of restrictions, regulations are made by the IRDA. So as a matter of fact, this sector has, I would say, to begin with, in India, how many insurance policies are sold? A question I put to myself. If I Google it, I find that approximately 17.5 crore policies are sold in the country, both journal as well as both life, non-life. I'm talking about, so look at the number. Such a mammoth is the number. 17 crore plus policies are issued. That means the insurance sector, insurance companies have to deal that much number of people. That means the customer base, the client, the consumer base is quite a big, quite a huge. So large number of customers, and certainly then there is a scope of large number of cases, disputes. If I put to you, there are many reasons as to why disputes happen. And as the topic today is legal jurisprudence frauds, if I put across the figure of fraud every year this industry faces, it will be a shock to many of you. It's about 45,000 crore rupees fraud every year. Such a big event is happening, and many of us are even not aware of it. Because I'm not going to take much of the time, we have got such a senior person, and I would say not only senior, but a seasoned person who must have handled cases in thousands. So you can understand what is his experience. And knowing him since last more than a decade, I have seen him working. I'm surprised when I met for the first time, and then secondly, I wanted to share it with you all that if you speak to Mr. Amber and talk about a case out of the thousands cases which are pending in his organization, he will tell you data of each and every case. That is what is the beauty when we deal with him. That is how he lends all the cases, and so he will be at the best, available to all of us to speak about what kind of cases we see. But to me, Amber sir, I have divided the frauds in the insurance industry into two. That's my own division. It's not somewhere explicitly mentioned or something. One is organized crime, organized, where a group of persons, they do some fraud with the organizers, and where I would also like to give one example also. And other is unorganized, where individual persons, for their own benefit, they do the frauds and dupe the hard public money, if I may use the word, public money for their own uses. Now, organized crime, the best example I would like to, 2 minutes I'll take. It is an example we have seen that in Haryana, there is a organized crime was happening, and where the persons who were terminally ill, they were insured, and later on, by showing false frivolous accident, they used to. So, and in that manner, more than 1,000 claims were taken from individual insurance companies. All these insurance companies, 34 non-life, 24 life insurance companies, and they were duped. Other than that, similarly, in individual capacity, people keep, they don't disclose many things. So primarily 3-4 type of cases in insurance industry. I will just name them, and then I will not take much of time, because such a senior person and such an experienced person is with us. So I think I should not take much of the time. The first type of category where I feel is where the cases in life insurance are repudiated, where the claim is repudiated. What happens? Sometimes the policies are lapsed, and clearly we see that non-disclosure of things are there. Supreme Court has very categorically stated that in case some information is desired and you are not disclosing that information, rather non-disclosure of information amounts to breach of fact, and that would be concealment of material fact, and that such repudiation is correct. So that a kind of such cases are there. People are suffering from some disease, they don't disclose it, they take insurance and then go for the claim. And such claim, if the insurance company, I wanted to tell my listeners here that these insurance companies, all these insurance companies have a very sound risk department. They scrutinize each and every case, whether the information is given is wrong or not. So that is one case. Then second type of cases are employee related litigation, because these companies have a lot of employees, so they are related. They take properties on rent, etc., etc. So property related cases. So primarily these are the width of cases which we see in the life insurance sector. So that's what the introduction, I would say, of the subject today. And now, with all my respect and regard to Amberji, I would request you to please take over and start the session for today. Thank you very much, and once again I welcome you for taking out time and being here. A lot of these people are really waiting to hear you. Thank you very much, and welcome, Amberji.
Am I audible?
Absolutely, you are audible. Your slides are on, and we can see you. Yeah, you can begin. You can start.
Thank you, sir. Thank you, Mr. Sanjay. Thank you very much for your warm welcome and providing synopsis of insurance fraud. And of course, we are always get enlightened whenever we discuss these issues with your good self. And of course, you yourself are well conversant with these facts. So first of all, thank you very much for inviting me for this session. I hope I will be able to do justice to this session. And if there are any queries, then we can of course take during the course of the presentation as well. And of course, thereafter also, I leave my contact details. If anyone would be interested, they can of course get in touch with me on the email. So without much ado, I'll just quickly start. Of course, a small disclaimer that whatever views and information I'm sharing, it is my personal opinion. It's not of the organization. And this presentation is only intended for teaching and education purpose. It's not a legal advice. Now, let us start first to understand some of the basics of insurance rather than first going into the detailed chapter of what is fraud and all about. Very important to critically understand what is an insurance. because once we understand what is an insurance, we can apply the law of frauds and how it applies. Now, in a very simple sense, law of insurance or insurance is a contractual agreement between an insurer and an insured. Insurer is an insurance company like Aditya Birla Sun Life Insurance, HDFC Life Insurance, and so on and so forth. And insured is a policy holder who gets his life insured with the insurance company. It's a protection of life of the insured for any loss or damage caused. And what is the consideration for this? Consideration is a premium. So insured is ready to pay certain amount of premium for continuation of his insurance cover. It also acts as a financial assistant during the death, survival benefit, income benefit, depending on the type of insurance that you have taken. Very simple term, right? It's also a contract of insurance is also established through this. Now let us understand some of the basic terminology when we talk about insurance and why these are important, because these will become very critical when we discuss this in the later part of my presentation. The very first important principle of insurance is utmost good faith. What does it mean, utmost good faith? In a very simple sense, utmost good faith means both the insured and insurer will observe a good faith and disclose every material information known to them, right? So how that information is disclosed? There is a proposal form in which the insurance company asks certain information of the insured or the policy holder, and the insured provides this information. It's based on an utmost good faith principle. If there is a history to that, but I will not be going into that detail. But very important to understand, it is the utmost good faith. The insured is in the moral, or not only law, moral obligation, but under legal obligation also to disclose correct and true facts. And that's how the utmost good faith principle is very, very important. Second thing is insurable interest. Insurable interest means any person who is taken an insurance or any person on whose behalf insurance being taken should have an insurable interest in that particular person. The purpose of insurable interest is that if there is something goes wrong with the life assured, there should be a financial loss caused to the person who is taking the policy. And that's how it's a very important principle of an insurance. If there is no insurable interest, then it can be a ground for avoidance of an insurance policy. For example, I myself will have an insurable interest in my own life. My spouse will have an insurable interest. I will have an insurable interest in my child. Grandson will have in grandfather. Sorry, grandfather will have in grandson. Similarly, debtor and creditor. There should be some financial loss that should happen, which I'm trying to take a security through an insurance cover. The third, which is most important principle of insurance from the angle of fraud, is material information. So whenever you buy an information, you disclose a lot of information like name, address, your phone number, your financial information, your professional detail, medical health conditions, and other so and forth. And law of insurance works on a material information. What is the material information? Material information under law of contract, insurance contract means relevant information that is important and impacts the underwriting decision of the insurers, whether or not a contract of insurance to be issued to life assured or not. Very important. We'll be using this terminology later part of the presentation a lot. So I just want to spend 1 second on more on this material information, that if every information, whether is a material or not, has to be disclosed to the insurance company. It is on the insurance company to decide whether that information is material or not. And if they feel they can give insurance, they may feel that information is not critical. They may, if they feel that is very important information, they may also ask the insured company to the insured to take the insurance after some days, increase the premium. So material information become very critical. Some of the example is, for example, your health style. Are you a smoker? Do you have a drinking habit? What about your medical information? Have you gone in any kind of medically ill, any treatment you have taken? Your income and occupation, what kind of business you are into? Do you have a criminal background? All these are very material information for the purpose of insurance. Next one is the proposal form. What is the proposal form? Proposal form is nothing but an application form under which the prospect fills all the information about the insurance that he's proposed to take in. That details basically forms the basis of an offer under the law of contract. So proposal form is nothing but an offer where the insured or the policy holder or policy owner or proposed policy holder fills all the details, which you all know, and submits that. It becomes an offer document, is an offer form for the insurance company. Basis that proposal form, the insurance company take the decision whether to accept the risk, also determine the rates and the terms and the condition on which the cover has to be granted. The proposal form, not apart from containing details of the insured, will also have details about the total amount of premium that has been agreed, what kind of insurance policy you have planned to take, the number of years, the banking information, and other various disclosures and undertakings which are there as part of the proposal form. Next one is agent and intermediaries. Now, agent and intermediaries are those who act as a linkage between you and the insurance company for the purpose of solicitation of insurance policy. Why it is important? Because most of us buy the insurance policy through agents and intermediaries. You can buy online also, but the large part of insurance is sourced through agents and intermediary. And many times, agents and intermediary, they fill up the form. They give the details because the insured said you can fill the form and I will sign and so on and so forth. So their role also becomes very critical in the overall fraud assessment and reputation of claim. Next one is reinsurance. What is a reinsurance company and why important? A reinsurance is a company which further ensures the entire insurance business for an insurance company. They underwrite the risk of the insurance companies as well. For example, insurance company has issued XXYY policies to so many individuals. They have to also reinsure themselves against the risk. For example, if all the insurance claims suddenly comes, ultimately is a capital. The reinsurance companies agree to underwrite certain part of the risk of the insurance company, and they also have a say in the reputation or rejection or the issuance of the policy, because there are certain limits within which these are agreed upon. These are the other important terminology that you should have a clarity, like free look. Free look is the time which the customer has been given to return the policy if he is not satisfied the terms and conditions of the policy. So normally 15 days time is given. So if you've got an insurance policy, you're not happy with the terms and condition, you feel that something has been wrongly displayed, wrongly told, you have 15 days time to return the policy. And if you bought it online, you can return it within 30 days. Similarly, grace period. Grace period is the time within which you can pay your premium. So example, if your premium has got due on 31st December, you would still have time of XX days to pay your premium. Presently, the grace period is 30 days. So you can pay the 30 within premium within 30 days. And during this 30 days grace period, your insurance cover continues. Something goes wrong to the life assured, the insurance claim will be payable. Similarly, but sometimes what happens that you are unable to pay the premium within the grace period, then you have a revival condition. You can always revive the policy, pay the unpaid premium with interest. These are very critical: your good faith, material information, and the proposal form. These are very three critical information and understanding of the terminology that should be aware of. Now look at the proposal of insurance stage and why the jurisprudence, when we talk about jurisprudence of fraud, this is important for all of us to understand. It starts with the proposal form. You fill the proposal form, you give the details, you provide all material information. You also agree to various declaration and undertaking. The agents also sign a confidentiality report that he has met the customer, whether he is not having any disease or not, whether what is his income, has he fit and fine. Based on that, the underwriter evaluates the proposal form and they may go ask for medical examination of the insured. So if the normally what happens if the limits are very high, or if the life insured had disclosed any material medical information which the insurance company would like to have a more detailed medical underwriting understanding, they may ask them to go for a medical examination. After that, the proposal form is scrutinized in detail along with the medical reports, and underwriting takes a decision based on the details given, information given, name, age, income, etc., type of cover, insurance cover amount, premium, duration, medical condition, and either they can reject the proposal form or they can accept. If they accept, they will issue the policy. If they reject, they will refund the proposal deposit, what is called as an initial premium, you can say. which is given along with the proposal form. But you look at the journey. You look at this is not a very simple journey, it's a very complex journey. At every stage, there is an opportunity for the insured to provide correct information, also for an insurance company to evaluate that information. Now, what happens if during the entire journey from proposal to insurance of each policy, something something has not been properly disclosed? For example, the proposer has not disclosed the material information. He was a heart patient, he never disclosed that he was a heart patient, right? Or he gives some the wrong declaration, for example, his income. He is looking for an income for, he is looking for an insurance cover of, for example, 5 crore, but his income is too low because there has to be a ratio of premium payment with the total income that you are earning. He makes a false disclosure of income and obtains the false insurance. Many times in case of term insurance, medical insurance or medical examinations are not called. It's a straight through process, a self-declaration process is there. You give the disclosure in good faith, insurance company relies on that and issues the policy. So this cycle becomes very critical because anything not disclosed here, wrongly disclosed here, falsely disclosed here, will entitle the insurance company to repudiate your claim whenever the claim comes. Now here the entire problem comes. And that is why we are here on to understand the entire jurisprudence of fraud in the life insurance industry. Of course, I'm not talking about general insurance. We have a separate aspect of fraud there. I'm today concentrating only on the life insurance now. And this journey is very critical, if you can see, right? And after the proposal form has been accepted, policy has been issued, you also get the proposal form, you also get your medical reports, you also got the contract. And the entire proposal form, insurance contract, disclosure of information has to be seen together whenever you have to issue a decide on the issue of whether it is a fraud or not a fraud. Okay. Now come to the policy contract. Insurance is a very customized. It's not a very customized kind of policy contract. It's a very standardized policy contract which are issued to the life assured, right? So what is the whenever you ultimately insurance policy is also an insurance contract. It comes under the Indian contract. It is a specialized contract which relies on the basic theme of Indian Contract Act plus the special contract of insurance. So whenever you buy an insurance, you are issued a policy contract, right? Now the terms of this policy contract are framed in accordance with the product regulation which are approved by IRDA, right? And it contains all the details related to your policy. So that's why it is being told that whenever you get a policy, insurance policy, please go through the details and also the exclusions which are there, right? And if you're not satisfied with the terms of the policy, you have got 15 days of free look to refund. Let us look at what are the important contents of the life insurance contract, right? So much details are there in your life insurance contract that there nothing can be concealed, nothing can be hidden. It contains the name of the product. It contains the person detail of the person who has helped, who has solicited the insurance policy. It also contains the name of the product that you have bought, the number of years that you have to pay the premium, if you the total number of years that you have to pay the premium, the total amount of premium, the benefit that will accrue to you, what kind of benefit that you pay upon surrender, upon maturity, or if there are bonuses, at what interval the bonuses will be paid. Have you taken any riders? Then what are the riders? What are the exclusion which are there? There are certain exclusions which are also there for which the insurance policy will not cover. When the risk has commenced, when the policy will get mature, how you can revive the policy, how you can surrender, what are the contingencies, right? Previous and your grievance critical mechanism and other documents and the conditions on which your claims will be paid or not paid. Correct? So these are the details which are there under the life insurance contract. So much information is there. Now, what happens when there is a claim? As I mentioned, their insurance policy contract also provides the conditions on which your claim will become payable and when it not become payable, right? So let us look what are the circumstances under which your claim will become payable or not payable. So there is a section 45 of the Insurance Act, which deals with the entire issue of the claim settlement. It is the It is the most controversial and also most talked about section in the entire insurance industry, especially after the amendment. So the insurance amendment, there was the Insurance Act 1938, which is already there, which got amended in December 2014. So let us look at a pre-amendment condition, and then I'll talk about what happened in 2014, and then I will take you to the post-amendment condition. Section 45 is the charging section under Insurance Act, which gives the power to the insurance company to call a policy in question. That is how it is there. When I say call a policy in question, meaning thereby gives an option to the insurance company not to honor the claim, right? In insurance, you are paying the premium at a particular event, which is the death event of death happens. You put a claim, and then insurance company evaluate the claim, and it takes a decision on section 45 whether I will calling a policy in question, thereby I will repudiating the claim, or I am paying the claim. If I am repudiating the claim or not honoring the claim, then it will be said that the policy has been called in question. Now, important thing is that since insurance is a special contract, the provisions of section 45 are contained itself in the policy contract. It's already embedded. It's not that somebody has to refer, like in case of Indian Contract Act, somebody has to go what is mentioned in section 172, 144, or section 17, which defines the fraud, right? So there they look at the aspect. Now, other important thing is that section 45 only applies to a policy of life insurance. So if it is a general insurance, section 45 is not applicable. So only a policy of life insurance is capable of called in question under section 45, and look at the grounds on which an insurance company can call a policy in question. So look at the pre-December 2014 condition. Earlier, before 2014, the section simply said no policy of insurance can be called in question after the expiry of 2 years on the ground of statement was made incorrect or false, or on the grounds of misstatement. So there was a 2-year period of limitation under which an insurance company can call a policy in question. But there was a proviso which stated that if the insurance company can show that there was a separation of fact which was material for disclosed or wrongly disclosed in a fraudulent matter, then the insurance company can also repudiate the policy after the 2-year period, right? So there was a limitation of 2 years and post 2 years. Within 2 years, you can repudiate on the basis of misstatement, and after 2 years also you can repudiate, provided you are able to demonstrate that there was a material information which was suppressed, or a material information was falsely given or not disclosed, and it was a fraudulently made. Now, what is fraud under section 45? That was not defined under the Insurance Act. And what used to happen that a lot of companies were repudiating the policy even after 2 years, because 2 years is that point where you have a limitation on the grounds of misstatement. But if you are able to demonstrate it is a fraudulent non-disclosure, then you can still repudiate after 2 years. So there was a joint parliamentary committee sat on it, and they recommended certain amendments to section 45 to specifically define fraud under the Insurance Act. Before that, fraud was never defined under the Insurance Act. Where was the fraud defined? Fraud was never defined under the Insurance Act. It was also not defined under the Indian Penal Code. Section 17 of Indian Contract Act, however, defines the fraud. The reason I'm picking it up because later on it has a linkage with the new section 45. So if you look at section 17 of the the Indian Contract Act, it defines fraud as any act which is committed by a person to deceive the other person to enter into a contract, and it lists certain requirements, right? A suggestion of fact which is not true, or the person making it does not believe to be true. There's an active concealment of a fact, of having a knowledge or belief of the fact, a promise made without any intention of performing it, any other act fitted to deceive, such other act or omission as the law specifically declares to be fraudulent, right? Now, important aspect is here is this fraud is an inclusive definition. It says fraud means and includes. So it is not an It's exhaustive. It's an inclusive definition. So there other criteria can also be added. So what the policymakers did, they took this base definition of Indian Contract Act and amended Section 45 to include the definition of fraud. Now look at what Section 45 of the Insurance Amendment Act did post December 2014. So it said that no policy of insurance can be called in questions on any ground after the expiry of 3 years from the date of policy. So they put the limitation of 3 years from 2 years, that no insurance policy can be called in question on any ground. The word is any ground after the expiry of 3 years from the date of policy. So when I say date of policy, this also include date of revival. I spoke about revival condition, right? So if your policy is lapsed, you can also revive the policy. So if you have revived a policy, it will be considered as a fresh policy. So even 3 years will be calculated from the date of revival. Then what it said, you can repudiate a policy of life insurance can be repudiated anytime within 3 years from the date of policy on the ground of fraud. So earlier it was mentioned misstatement. Here they have brought the definition of fraud, and they say within 3 years you can repudiate a policy or call a policy in question on the ground of fraud. And fraud is not defined under the Insurance Act earlier, and they have now defined. And they have used the same definition of Section 17 of Indian Contract Act and applied in the Insurance Act, which is I have listed here in for the benefit of all. Same thing, if you can see, fraud means the following: suggestion of a fact which is not true, which the insured does not believe it to be true; active concealment of a fact, having knowledge or belief of the fact; any other act fitted or deceive to deceive; such other act or omission as the law specifically declared to be fraudulent. And what is the main principle? The main principle is the same: non-disclosure, misdisclosure, false disclosure with an intent to deceive the insurer or induce to issue a life insurance contract. So here the intent is very critical. So intent has to be malified. Intent has to be for the purpose of fraudulently inducing somebody to buy a life insurance policy. Examples I can say, for example, somebody is a very basic example. Somebody is 80 years old and the policy requires the entry age of maximum 60 years. Somebody fraudulently makes a declaration that I am 54 years of age, gives some false document also, policy gets issued. Now the question in the proposal form that what is your age? It says that he gives 54. Now by giving a false disclosure, an information, he is known that it is a wrong disclosure. He inducing the insurance company to issue the policy. Later on, if the insurance company comes to know that the right age is of 80 years, then such non-disclosure or a wrong disclosure will fall under the definition of a fraud. Similarly, medical information. Somebody has given a medical, there is a question, somebody says, are you taking certain medicine? Are you under treatment XYZ? And somebody is already taking a decision. Somebody is already under medical treatment, well aware of the fact, but he does not disclose, then it will come in the definition of fraud. Now, there is another angle to the entire Section 45, which makes the entire jurisprudence of fraud under insurance and very, very complex. It's not simple. I have not touched base upon so far. In the next slide, why the entire confusion happens and why it makes it so complicated. Let's move to the next section of 45, which is subsection 4, right? When it says that insurance policy can, a life insurance policy can also be called in question within 3 years due to any misstatement or suppression of fact material to the expectancy of the life of the insured was correctly made in the proposal form, right? So now you have one fraud definition which say that you can call a policy in question. Now there is subsection 4 of the Section 45, which also gives you a right to call a policy in question if there is a material statement made, misstatement made, or there is suppression of a fact which is made, which is related to expectancy of a life of the life insured and it was made incorrectly, and on the basis which was policy was issued. Now there is a complete confusion. You have one Section 45 subsection 1 which say that You can call a policy in question due to fraud, and then you have given all those things. And then you have also one section which say that you can also call a policy in question within 3 years if there is incorrect statement is made by life insured in the proposal form, and you found that it was a misstatement. There is a proviso which further there is an explanation which further said what is a misstatement or separation of fact. So to a misstatement or separation of fact will be considered material. So it has to be a material. For example, somebody says I am 58-year-old. Actually, somebody says I am a 45-year-old and actually is a 50-year-old, right? So it's a separation of fact. Now, whether it's a material or not, it has to be seen from two tests. First, it has to be a direct bearing on the risk undertaken by the life insurer. And second, had the insurer been aware of this, he would not issue the policy, right? So now that is how they have tried to distinguish between a material misstatement and a fraud. Now, there is always a confusion what is a material misstatement and what is a fraud, because on the basis of fraud also you have to repudiate, and also on the misstatement also you can repudiate. But the act distinguishes the aspect that if you are repudiating a policy due to any material misstatement, then you have to refund the premium. So it is going back the section 20 of the insurance of the Indian Contract Act, dealing with the principle of void and voidability. So I am voiding the contract because you have given me a wrong disclosure, and therefore I am taking the policy null and void, and I am refunding the insurance premium as if there was a no contract, because you have misstatement made and you have induced me to buy this issue this insurance policy. The act said, okay, no problem. If there was a misstatement, you refund the insurance premium. But in case of fraud, which is an act of criminal nature, willful misstatement, intention was bad in law to induce you, then you can forfeit the premium. That is how the section 45 is creating a two balancing act post 2014. And of course, more than answers, it has posed a lot of many questions, which I will also deliberate in my coming presentation, and make the entire life complicated for people like us who work in the insurance industry and my claims team when it comes to repudiation of the claim. Because how do you distinguish between a material misstatement? Because in both the condition, the insurance company would have not issued the policy. In the fraud also, you'd have not issued the policy. In case of material non-disclosure also, they have not issued the policy, right? Material also was never defined in the Insurance Act prior to 2014. After 2014, they have defined the material, which I mentioned. It has a direct bearing on the risk undertaken by the insurer, and the fact which was known, life insurance policy would have not issued the policy. So there is also a regulation called Policyholder Protection Regulation 2017, which was earlier in 2002, where the word material has been defined. And we used to take the definition of material before the new amendment came, which said that material means and include all important, essential, and relevant information in context of the underwriting the risk to be covered by the insurer. Meaning thereby, all kind of information has to be disclosed, whether financial, non-financial, which is important for an insurance company to underwrite the risk or issue the policy. More or less similar definition has been used under the Insurance Act, right? Now, what happens when there's a fraud and there's a merely a non-disclosure of fact, right? Now, in case of fraud, the onus is on the insured that to prove, I have to prove, the insurance company have to prove that misstatement was within his knowledge and there was a deliberate intention, and such information was issued for the purpose of inducing. One example I am telling you. For example, somebody was already under treatment of cancer, and there's a question that have you been diagnosed with cancer? That person is already under treatment. He is taking chemo, he is taking medicines, he writes no, right? Now that is a misstatement of a material information, yes. Whether it is a separation of material fact which was when it is his knowledge, yes.
Yes.
there was a deliberate intention to suppress the fact? Yes. So now whether it is a fraud? Yes, because there was an active concealment of a material fact. Scenario 2, the person took the policy, he was having a liver cancer, but he was not aware of the disease. Because liver cancer, for example, it can work in your body till 80% the liver can work, you will never come to know, right? But you are never aware. You took the policy, you were healthy every day, you were enjoying your life. But the cancer was already there in your body, you were never aware. You took the policy, after 6 months, you suddenly developed certain symptoms, etc., and you went to the doctor. Doctor did the CT scan, etc., and they found that you are in the last stage of liver cancer. Hence, the life insurance life dies. Now, whether there was a separation of material fact, yes, there was a separation of material fact. Whether there was deliberate intention, the answer is no. Whether that information was well within the knowledge or belief of the life insured, the answer is no. Why? Because he never believed that he was having a cancer. He was not under treatment that he was having a cancer. No medicine was having the that he was taking for cancer. Yes, there was a material separation, but he was never aware. So then that will fall under subsection 3, which I spoke, that it was material to the expectancy of the life of the insured and which was incorrectly made. So it was an incorrect disclosure made by the insured, but it was not made with a willful intention. It was not made because he was well aware of this knowledge. And therefore, the Insurance Act says that in such cases also you can repudiate, but you refund the premium, because anyways you would have not issued the policy. If you would have done some medicals, etc., you would have found to know that that disease or that insurance policy is not to be issued because it's an advanced stage of cancer. You would have never issued the policy. This links with the concept of unjust enrichment. So please see the insurance law, how they have beautifully crafted and used various provisions of insurance contract act in the insurance contract. You know the Indian Contract Act on the principle of unjust enrichment, which means that one person should not be benefited, take profit or gain at the expense of other. So if I made certain honest declaration, which I believe that was true, and I paid you certain money, which you felt that was the wrong thing, and you would have not issued the contract, you have not entered in contract, no problem. You avoid the contract, but refund the premium also, because you cannot get profit and applying the rule of unjust enrichment. Very beautiful concept. But now these are very good concept to discuss. But the problem comes when the actual case come. Because how do you prove whether it was a material non-disclosure? How do you prove whether it was an intentional non-disclosure? How do you prove that there was an active concealment of material fact? So all these issues start coming when you start evaluating the claim, right? So there's always, you have to balance between what is fraud, what is material separation of a material fact. In a very simple sense, because it's a very complex subject and there are n number of judgment, I'll try to also cover few judgment. But a very basic principle which we apply, which I at least apply, and which most of us, or you, if you are working in an insurance company or representing, you have to distinguish that where there was a willful intention, where there was a willful non-disclosure of a material information, again it has to be material, which was well within the knowledge of life assured. With the example I just gave of a medical information, that he was well aware, he was already aware, right? Where there is an element of malafide, or mens rea, you can say, a criminal intention to some extent, then it will be a fraud. Where it's a mere an oversight and unintentional non-disclosure or misstatement or an incorrect statement which was not within knowledge of a life insured, then it will fall under the definition of material separation of work not amounting to fraud, right? And in fraud, you forfeit the premium. In case of material separation of fact related to life expectancy, you refund the premium. For example, age, again I gave you an example. Somebody says that I am 50 years old, but actually his age was 55. right? And now typically at the age of 55, insurance company would have called for medicals. At the age of 50, for some particular product, there is no insurance called. No medical examination is called. Now later on comes to know. Now, in this case, even at 55, you would have issued him the policy. But there was a separation fact, yes, but there was a fraudulent intent, maybe not, because it could have happened due to any poor knowledge of, or somebody else has just told, sir, up, like approximately 50, somebody illiterate is there, somebody, he was not aware of much, somebody in the village bought it. So there you apply these kinds of principle. I have certain case laws in the next presentation to distinguish these kinds of two concepts. What will be a fraud, what is a material separation of fact. But these two basic things you have to be well aware: intention to deceive within the knowledge versus not intention to deceive, or which is not within the knowledge of the life insurance, right? There are some examples. When you repudiate a policy on non-disclosure of medical history, what are good way of evidence? Because we are not lawyers, we have to weigh our evidence, right? So we have tried to compile some FAQs or certain listing what will be. So some of the green ones are good examples of evidence, because everything in law works on evidence. While this conceptually everything is good when it goes to consumer codes, forum, commission, civil code, it's the evidence work. So these are green ones represent good evidences where you can establish non-disclosure of past medical history was material, it was intentional, like discharge summary, admission record, medical examination record, medical leave, right? Now, second one, the red one is a weak kind of evidence where non-disclosure may not be amount to a fraudulent thing. For example, post-issuance medical history, which I just mentioned, the person was not aware at the time of policy, but he was already having some disease inside the body. He was not aware, right? So the copies or reports are not attested. They are not properly legible. The details of insurance insured in the medical documents are not proper. So these are some of the examples of good and bad, and weak or strong evidence. Misstatement of age. How do you establish that somebody was having the right age? Somebody says I am 45. Later on, you come to know that he's 60 years. So the green one indicates a good evidence towards the establishment of wrongful statement of age, like PAN card, passport, Aadhaar card, 10th admission card, or your mark sheet, family tree. Person says, I am 30, I am 40-year-old, and he already have a son of 45 years. This is not possible. So this is also a good example which we have used in many cases. Sanjay is aware of, he has won some cases for us also on these grounds. Voter ID is not a very good evidence to prove misstatement of age. But I will show you one judgment in a case where it was used as a good example, because now how you produce and how you collaborate to use it also becomes a critical example. Similarly, death before issuance. Now, death before issuance, somebody was not alive. Somebody, the LA was himself not aware. It's an active concealment of fact. Straightforward. It's a fraud. There's no debate about it. Somebody has made a fake death certificate, tried to show that he has actually died after the policy, but he was died actually before. So some of these good examples: cancel DC, crimination certificate, FIR if you've done something, extract from birth and registrar. Now, sometimes we witness there are two death certificates. There's some letter somebody writes about the death of the person. So all these are weak evidences to establish some of these areas of right. Income and occupation also become very critical. Somebody says he is a laborer. He said, I am a businessman. I am earning an income of 10 lakh rupees, and takes a term insurance plan of 1 CR. Later on, it comes to be he's a BPL card holder. So that's a bad thing, is a wrong disclosure, and it's a fraudulent disclosure. So some of the document that you can use to demonstrate and fight is BPL card, ration card, income tax certificate, bank statement. So if you are able to procure any of these, some of the documents, you are able to substantiate some of the frauds as a strong evidence, right? Now let us certain case example. Now here the fun begins, right? Now the first example I will take it here is, no, first I'll take, yes. This is a good case of very, very recent case. I think in October or I think December to January 2020, this case was passed. Gulab Singh versus HDFC Standard Life Insurance Company. Now here what has happened, the person has taken the policy, he has given his date of birth XX. Later on, it came to know by during investigation the person's real age is YY, which is he is beyond the insurable age, right? And the age proof that was given by him was a PAN card, right? Now PAN card mein there is one age, but during investigation they came to know on the voter card, and in voter card his age was much higher. But I mentioned you that voter ID is not a strong evidence. But in this case, what happened? The claimant, the nominee of the claimant, when the claim was got refuted, the nominee of the claimant filed an affidavit in the court of as part of his complaint that my father is of so and so age, so and so person and all. And as part of his proof of relationship, he attached the voter ID, which had the real age, and the nominee relied on that voter ID. Very beautifully, the advocate in the matter and the company, respondent company, took that plea that the age proof has been submitted by the nominee, the claimant itself, which indicate a different date of birth than the date of birth which is mentioned in the application stage, which was more than the age on which he was eligible for the insurance. Here, the fraudulent thing came into picture, whether it was a fraudulent thing or mere non-disclosure or a misstatement. Clearly here in this case, a good example that non-disclosure of a correct age, which has been supported by an evidentiary document, will be considered as a fraudulent intent, because that fraudulent intent was very much apparent at the application stage itself, because the LA was was aware that he is beyond insurable age. He used a fake PAN card, or sometimes at the time of buying insurance, a lot of people buy it, they get the PAN card, because PAN card there's no document required. You just have to put an affidavit and you get a PAN card. But then other document, even though it was a weak document, court, the National Commission, this matter went up to National Commission. Be mindful. Huh? The National Commission held that there was a fraudulent intent which is clearly apparent, and the insurance company has repudiated the claim due to false age, as correct disclosure was not made, and it was material to disclose the correct age. That is a fraudulent. Their intention was wrong. Their intention was deceived, and the insurer was the insured who was applying. He was well aware that he's making a wrongful statement, right? Now, many times it happens now, medical non-disclosure, as I mentioned. Very good case in Life Insurance Corporation was Rajesh Kumar, and which was used in another judgment called Reena Karmakar versus LIC. Now, many times, a lot of insurance companies, they also conduct medical examination, right? Because of the high value of the claim involved, say XCR, depending on their underwriting policy. So in this particular case also, the life insured was called for medical examination. And so when you fill the proposal form, as I mentioned, you have to give the correct information. When you go for medical examination also, you have to make a disclosure. The doctor asks various kinds of statements, and you have to give correct detail. In this both the cases, the life insured mentioned everything negative, that he was not suffering from XYZ and all this. Later on, when the claim came during investigation, the insurance company found that that person was already in medical leave by his employer during XX days. He was suffering from disease XXX days, and he had undergone full treatment, and complete disclosure of documents were there. And the claim was repudiated. So matter went up to the National Commission also, because of the law, and the claimant took a plea stating that even if I have not disclosed, doesn't matter, because the insurance company has undertaken my medical test. They have appointed that doctor at the panel. They should have examined me. And if they have examined me, then that medical disclosure was not found. So I was not suffering from any disease. And now there is a deficiency on his part by repudiating the claim. National Commission, however, held just the opposite. And in fact, in the past, they have held that if they have done the medical, then it is because medical officer represents the insurance company, then they will be bound by their report. But in this particular case, again the fraudulent thing came into picture. What is the intention? Whether was an intent to deceive? Yes. Were the fact which was known to the life insured? Yes. Both the things were established, and National Commission held that merely just because a doctor has been examined by a panel of doctors of the insurance company, it is not possible for the doctor to detect all the elements, because there are many elements you can't detect unless until you do a CT scan XYZ. Or for example, you might be under medication and you may not be able to test reports or blood reports can't reveal that. So it is for duty to disclose all the correct information related to medical by the insured in the question in the proposal form. The principle of good faith was relevant. It was it was ruled that good faith is very important, and if somebody is not making that truthful disclosure, it will amount to a fraud. Same principle was applied in one other case law, Reena Karmakar vs LIC, where it was held that life insured is under obligation. Remember what I said in the initial presentation? Good faith obligation is there. So you are under obligation to give a truthful answer to all the questions. Just because somebody has examined by a panel of doctor of the insurance company does not absolve him of his obligation and disclose correct medical condition. So the insurance company was held, decided that it was correctly repudiated the claim. Very thin balance, very fine balance you have to make. Again, fraud versus non-disclosure of merely a non-disclosure material information. Willful non-disclosure, material fact, intention to deceive. All the three things has to be established, right? Now, I will touch with favorite uh, case, which my honorable friend, colleague, mentor, guide, Mr. Sanjay Chadha himself has represented in this case. And
Thank you very much, sir, for remembering.
yeah, this I have purposely put because very landmark judgment has come under Reliance Insurance Company versus Rekha Ben Rathore. Now, I spoke about income, I spoke about profession. There is another element which is very, very important about the insurability of a person. In case of insurance, everybody is subject to certain insurance amount, because as I said, again, going back to the principle of insurable interest, right? There has to be a loss, a financial loss which is caused due to the death of the insured, which is capable of being insured. And what is the financial loss? It is a sum of many aspects, many other things, right? Because it doesn't know your income, your occupation, your lifestyle. Because ultimately it's a financial game, right? For example, when you go and take a loan, your credit worthiness is looked into, how much loan can be given. Similarly, when you go for an insurance, your insurability is also looked into. So it is very also important that total insurance that you are taking should meet your overall capacity of payment of insurance, or how much your income is earning. And that's why if you see, whenever there is a question, there's a specific question that have you bought any insurance before this policy, or your has been rejected by earlier. So that whenever you buy and apply for a new insurance policy, the new insurance company is well aware that how much insurance you have already taken based on your current income, right? Now there have been many judgments in the past whether non-disclosure of a, so what happened, a lot of people don't disclose it. For example, there is a person who is a very low income group, or even a middle class, earning XX amount rupees, and the number of insurance premium that can be given is also subject to certain percentage, and a maximum insurance cover can be given. Somebody who is earning a income of 50,000 rupees cannot be given a life insurance cover of say 10 crore, 50 crore, 100 crore. There is a certain limit, which of course every insurance company formula differs, but normally it is considered 10 times of the premium that you have agreed. This is a standard practice. So that's why very critical to give a proper insurance policies you have taken before the applying to the new policy, right? And it becomes a material information. So there were a number of judgments before that, but this was finally got resolved in this particular case and in the Supreme Court, not in the National Commission, and in the National Commission, not in the Supreme Court. So what happened in this case? So there was the life insured. The person has not disclosed his prior insurance policy, have taken many insurance policy before applying to Reliance Life Insurance. All the three commission level And the insurance company repudiated, saying that, boss, the maximum insurance can be given this much. He had already over-insured. I can't give more insurance, and it was a material non-disclosure. I'm repudiating the policy. The matter went into lower forum, district forum, commission, state commission, and national commission. All three of them said that this policy cannot be issued. This policy can be, the reputation done was not right. Then the insurance company, life insurance went, Reliance Life Insurance went in appeal to Supreme Court, and which was also represented by Mr. Sanjay Chadha himself. And the Supreme Court overruled that and clearly held that failure of the insured to disclose the policy of insurance obtained prior to the insurance entitled the insurer to repudiate the claim under the policy. Any separation, untruth, or inaccuracy in the statement in the proposal form will be considered a breach of utmost good faith, which I spoke in the initial, and will render the policy viable by the insurer. Very landmark judgment. So very important that pre-insurance policy details are also to be given. Now, the only catch here is that in this case, this was happened pre-2014 scenario, and this policy got repudiated within 2 years. And ground of repudiation as a material non-disclosure. But had it been after 2 years, or maybe in case of new insurance act, we have to prove the fraud. But here also it is easy to prove the fraud, because again, material separation, yes, and information was well known, yes. Was it material? Yes. Where the intention was to deceive? Yes. A very important judgment. I spoke about these important aspects of medical prior insurance policy. Now I'll take something on the income aspect. Now, many times this is a case of Neetaben Mukund Shah versus BSLI. This is our company case, well quoted in the National Stock and the National Commission. In this case, the gentleman, in order to take he was a businessman. In order to take a higher insurance cover, he declared a higher insurance in the proposal form. Later on, during investigation, it was found that his actual income is very low, and he was not entitled to take so much of insurance cover. The matter was repudiated, and it was above 1 year. It was before the new Consumer Protection Act. So matter straight went for original jurisdiction in National Commission. There, the National Commission looked into the question whether non-disclosure of correct income or a false income is a fraud or not. This was a specific question when we fought, because the policy was more than 2 years under the old Insurance Act, which I mentioned that it is after 2 years, then it is important for you to prove a fraud. So we had used the income tax return of last 3 years, which showed the correct income and which clearly demonstrated that the actual income which was shown in the application was much higher, inflated, and an income tax return was very less. The National Commission, very beautiful judgment. I think most of you should read it. It's one of the landmark judgment on the fraud on the insurance income, where National Commission clearly held that disclosure of correct income is a material information to the insurance company, and making a false submission by the insured constitute a fraud under the Contract Act. Mind it, earlier Insurance Act did not have any definition of fraud. It relied on Section 17 of the Insurance Contract Act 17, which said that active concealment of a material fact with an intent to deceive. They relied on that, very beautifully contested by our counsel, and finally the matter was won, right? So this is another very important judgment on distinguishing between a fraud versus a material, merely a misstatement of information. Now, this is the last case study, because I think time is also limited.
And we have a lot of questions coming for you.
We'll answer that, don't worry. And I have a food for thought for all you guys. It's another case of 2018, where certain details of foreign travel was asked as part of the insurance policy, right? That person has traveled foreign and all those things, and he caught some XYZ issue, and later on claim was lodged. The insurance company denied this claim, stating that there was a question that whether you went for a foreign travel, which you actually went for a travel, and you did not disclose that yes, you traveled, and therefore I am repudiating the claim. Now here, important aspect, whether travel information detail given in insurance policy, the information material or not, that came into picture before the National Commission. The National Commission had said that yes, there was a duty to disclose. Yes, there was a question about foreign travel, but it is not clarified that how foreign travel has criticality with respect to issuance of policy when you have not given what are the countries under which if you travel, I will not issue the policy. Therefore, National Commission held that non-furnishing of information about foreign travel does not amount to material concealment of fact for the assessment of this. So here the non-disclosure was not found to be material. Even if it was a non-disclosure, it was not a material non-disclosure, and National Commission held that such kind of non-disclosure will not open the definition of a fraudulent intention. It could be a non-disclosure, but not a material separation of fact amounting to fraud, and therefore the insurance company was not right in refuting the claim. Now I have a note for thought for all of you. If we apply this context in the current scenario, in the COVID, when there is a current situation prevailing, foreign travels are banned, there are restrictions, and every insurance company is specifically asking, where have you traveled last 14 days, which country you have traveled, which city you have traveled, which is the state you are traveling. And in the current scenario, if somebody said that he has not or he or she has not traveled, for example, somebody came from all the way to Singapore and applied for an insurance policy, and at the time of insurance policy, the question is that have you traveled in last 14 days in any foreign country? Somebody says no, and later on the person gets COVID and he died because of COVID. Now this is a food for thought I am leaving for all of you, whether in such case a non-disclosure of that information of foreign travel will be considered material or fraudulent or not. So these are the views I want to close for food for thought for each of you to think about it. And with this, I come to my end of the presentation. I'm happy to take any questions. And if you, these are my coordinates, my Gmail ID, ambergupta17@gmail.com. I'm there also on the LinkedIn. If anybody has, and if, of course, I'll answer most of the queries which I could today, but due to positive time, if I'm unable, I'll be happy to answer them. So that's the small summary of presentation on legal jurisprudence on fraud. Very difficult to summarize this because there are philotheras of judgment on this, but I've tried to do justice on 3-4 specific aspects of income, age, and medical non-disclosures, and explain the concept. And of course, Mr. Sanjay himself is a veteran in this particular industry and will be a guiding factor for us in case we also get stuck. So that's from my side. I hope you have enjoyed the session and I was able to do justice in the given time. I'm open for questions, sir.
It was a wonderful session, Amberji, and the way you have really taken up each and every minutest, I would say, when we were talking about the concealment of material fact. Can you remove the slides so that we are on the screen now? So we have several questions also which are there, and as I was saying that you have took minutest of the details, like what is concealment of fact and how wonderfully you have taken the Insurance Act 2014 prior to the amendment and after amendment. So there are a lot of such things, you have detailed, I feel, in such a short time, in a very, very extensive way you have presented it. Akanksha, then can you have questions? Can you take up the questions which are there in the... Many of them are there in the YouTube, actually. So let us take them one by one. One is one question Preeti Arora is asking as to, meanwhile you can take out, I've just read, so I'm sharing it with Amberji. The first, that if a person is extensively been checked by the panel of doctors exclusively appointed by the insurance company, then on how can this this be applicable? Because once you check it and thereafter, after 3 years when he is no more, then you say that look, you were taking this treatment or something like that. So just elaborate on that.
Yeah, so
Because
I
this-
think there are two judgments I quoted of National Commission, which somehow answered. See, please understand, again, go back to the basics. Principle of utmost good faith.
Good faith.
So the insured, the life insured is under duty to disclose.
Yeah.
Just that particular duty to disclose cannot be taken away just because some panel of doctors has examined that particular person. Because please understand, the examination which insurance company does, it's not a detailed examination that you are being taken through a CT scan or ultrasound.
Exactly.
It's a
I would
basic,
say it is a clinical examination.
it's a clinical
And this-
examination. Yeah.
Yes, exactly.
And depending on the type of insurance cover, of course, if you take a small insurance cover, it's a basic health, information, basic blood report. Higher insurance cover, then treadmill test, etc. is also taken, etc., etc. So depending on what. But
Yeah.
as I mentioned, if you, it will not give the complete details because it's very difficult to examine and get all the details. But the question is again is that active concealment of a material fact. If the person who is taking the policy was already undergoing that treatment,
And you are
was-
aware.
yeah, you are aware, you are taking the medicine. Sometimes by medicine, you can also hide your disease, or you can manipulate your blood reports.
Yes.
Therefore, the law says the responsibility, the obligation of utmost good faith is on the insured. You should disclose. Merely somebody has examined you will not.
And one more
Yeah.
thing I would add on for the benefit of the students, law students who are here in large number with us. It is simply a contract of insurance. Kindly appreciate, and it is not the insurance company which is proposing. You are proposing. So you have to propose the, as Amber sir has just said. So you have to propose the correct thing. And as a matter of fact, when you read the law of contract, you say contract of insurance is a contract of utmost good faith. That means we believe whatever, blindly rather, insurance company believes on the proposal which you furnish to them. If you are specifically mentioning, no, this disease is not there, it will be taken on face value. So if the statement is wrong, that means it is your fault. You have to go. Similar was the applicable, similar law was applied on this Reliance judgment, Renuka Ben. That's also is on this. You knew that you have these policies, you have not disclosed those policies. So you are not liable to take any benefit out of these policies.
The only thing is that if you are not in treatment, you are already not undergoing.
Yeah,
And,
then
and after that, you figure it out, and you may be symptomatic also, but you are not fully aware.
yeah,
Then probably benefit of doubt can be taken, and
Can be taken.
court may rule in your favor because that you have done,
exactly.
but not the otherwise. Again, fraud versus non-disclosure. Again, the same.
Exactly. No, you have rightly, very simply, you have explained it. So the
Yes,
same question came from Savitri also. So Savitri must have got this reply. Now, other Ruby Chatwal wants to ask why doctors are not instructed to do medical on full scale so that the disease is detected before the signature of the policy. Now you give the answer to this.
So the thing is that insurance company is not into the business of doing a physical examination of the life insured. Again, as Sanjay sir has also mentioned, I mentioned, you are under duty to disclose. You should disclose. The insurance company will take a decision whether to issue a policy, do a further investigation or not, etc., etc. And second thing is also there. If you go for a detailed examination, it is a cost issue is also involved, time issue is also
Yes.
involved.
Yes.
So then what you will do, you apply, you know that you are under thing, you will get your examination done free of cost, and the insurance company later on denied, you said, fine, I've got examined. It is not that the thing happens.
Yeah.
And
Cost
therefore,
is one of the important factors. I feel.
the insurance premium, ultimately the premium has to be paid by the insured, so it will add to that. However, these things have been considered by law, by the law ministry, and that's why now this concept of 3-year limitation has come, which says that you cannot repudiate the policy after 3 years on any ground.
Yes.
So that's why earlier a lot of people were repudiating policy after 3 years on these grounds only, that it was a fraudulent non-disclosure, you are having some medical treatment, But now the insurance companies can't do that. So even now, within 3 years, you have been issued the policy, insurance company can examine you, they can do an investigation on you, but three year is the limitation of law. After 3 years of the policy, on any ground, even it was a non-disclosure, a material, a fraudulent non-disclosure, as per law, it has to be tested in the Supreme Court, and I'm sure somebody like Mr. Chadha will definitely be arguing some this matter come, and
To
I'm
that,
also
to that,
legally.
I would just want to say
Yeah, I
something.
just complete that.
Yeah,
So
I'm so
that
sorry.
new act ke andar, now this the issue is there. So what you are saying is correct. And the new act, somebody after 3 years and then later on comes to know that he was having a cancer, he had not disclosed, then probably under section 45, insurance company will not be in a position to repudiate the claim, subject to judicial review as and when may happen. IID has mandated insurance company not to repudiate it, but I'm sure that some judicial review will happen because misuse of section 45 should not be there. And now Mr. Chadha was saying.
I wanted to very bluntly, I want to tell this to all the listeners here, that section 45, this is a defect which Amber sir has just touched. It is a defect. If I come to know about this fraud today, it is against the principle of limitation law. I feel if you detect the fraud today and those 3 years have already gone, what can you do? That means you are barring somebody. Insurance company was not aware about that fraud, and 3 years have lapsed. Let's say if I do this fraud and a very big policy is taken, let's say for 5 crore rupees. For 3 years, I pay premium of 20 lakh rupees, big premium. 60 lakhs I paid. After 3 years, it becomes non-challengeable. You can't challenge it. I have to get 5 crore rupees. So I feel that this goes against the fundamental principle of law of limitation. That means then the insurance company, what insurance company, if that is law is even approved by let's say Supreme Court, then insurance company will go on do one thing, that you should file a criminal complaint against such person. I mean, that's what is coming to my mind.
I can't comment on anything because it's a matter of policy and all those. So I just said the law is there, and I'm sure, as I mentioned, that somebody may challenge it in a later part and will be eagerly waiting.
I think it is a very well challengeable provision, because you cannot in any way bypass the law of limitation. Law of limitation cannot be bypassed. That's what I feel. One more question which is come here. This question is pertaining to one point, that most of the time, this is asked by Neetu Khanna. She says that most of the time the insurance forms are filled by the insurance agent himself. So can you please throw some light on it? Once the insurance form is filled by the insurance agent and he feels, let's say, something wrong, the person insured says that I was telling him the correct thing, his defense is this, then what you will do? What is the fate
very
of...
very valid question, very valid question it has, but I will answer that in a two part. Again, one part is that even if there are many judgments which has happened, I'll not get into that in that area. Once the insurance policy is issued, along with the insurance policy, as I mentioned, you get the policy of insurance, you get the copy of the proposal form, you get all the documents along with your policy contract. So at that point of time, the insured has an opportunity to go through the entire application form. He can see if something wrong has been given. There is a provision for free look. He can call a policy and can say, this policy is wrongly given to me, these details are not correct. And therefore, he could have exercised the free look period. So that option, that is why it has been given.
Yes.
Later on, what happens that I will first talk about the legal principle, and I'll come to exception. The rule of estoppel comes into picture. You have paid 5-year premium, 7-year premium, 3-year premium, whatever, you remain silent. So you have kind of accepted that particular fact because the proposal form is signed by you. Unfortunately, the signature is the important aspect. Whatever has the agent has filled in, ultimately it is signed by you, which is deemed to be that you have read and you have accepted those disclosure. Your signature indicates that, because there's an undertaking that I've read and understood, the questions have been given by me, and so and so and forth, right? There are many judgments also where Supreme Court also and National Commission has also held that it may be true that the agent has filled up the form. However, the moment you have signed, it is deemed to be an acceptance of those information which has been given by you, and therefore later on you cannot go and deny that it was given by XXZ and it was a wrong information. There is a latest judgment also which has come. I am unable to locate the name of that insurance company, but in that particular case, same thing has happened. There was a non-disclosure of income. Higher income was disclosed to take on higher insurance, and it was repudiated by the insurance company, and same contention was taken, stating that this wrongly was given by, I have never told them. But court held that since you have signed it, it will be binding on it. The only exception will be, which comes into principle, is natural justice. Somebody, he is not, for example, illiterate. He has applied his his thumb impression. He is not able to read and write the policy, and he was undergoing for some medical information which is not properly disclosed. In such cases, sometimes court takes a fair view and from unfair trade practice angle, and may apply their jurisdiction and overrule that as a matter of equity and justice. But in principle, since it is signed, you had the opportunity, rule of estoppel will apply, and therefore it will be binding on the insured.
Honorable Supreme Court in LIC, one of the LIC case, I don't remember the full name, has stated that when an insurance agent or advisor is filling the form, he becomes the agent of insurer, the person who is getting insured. So he fills the form in capacity of your agent. This is the wording used by the Supreme Court. Now there are 2-3 more questions. One very interesting question has come from Sudhanshu Sethi. He says that insurance portability among other companies have started in India or not? Insurance portability has started or not?
So in health insurance and general insurance, health portability have started. But in life insurance, insurance portability has not yet started. Yeah, that's the answer. So health insurance, and it is possible you can do the portability, etc., etc. And so if you're interested, most of the insurance company offer it's an IID mandate.
Then now there is a, sir, the bifurcation for the admissibility of evidence. It is very popular. You have just very rightly shown certain documents, certain piece of evidences which are strong evidence. So Preeti, bifurcation of admissibility of evidence, red and green, were really useful. However, I had a doubt as to how this bifurcation will be done in case of on case-to-case basis. Now, this is, I feel, this is being done by, to simplify it for you. By Amberji, it is being done. It is not elaborated.
No, we have done based on our experience.
Yes,
I
yes.
just thought to touch base that, how because in everything in insurance, evidence is everything. Not, it's a case, actually in case, evidence becomes critical. And many times we know that there is a non-disclosure. We know that person is not alive. We also know that the person has wrongfully made a disclosure, but evidence is not there. Or we are fighting on the basis of weak evidence. So court gives the benefit of doubt to the consumer, because ultimately, benefit of doubt has to be given to the customer itself. If because we have to prove, we have repudiated the claim, so insurance company has to prove. So we have done this. I just thought to share with you all. And it's not there in the law.
Yeah. 2 more questions I'll take. One is Sudhanshu is saying, we see many a time to achieve sales target, agents, they enroll policies and connive with the person and concede certain medical disclosures by saying this is lack of lockup period is far such as period. I mean, period will pass on. This is, if it is 2 years only, lock-in period kind of thing is there. So this is there existing, and many people adopt this. How insurance companies are tackling such thing? Do you face things?
Yeah. So as I mentioned earlier, the insurance company was given opportunity to even repudiate on the basis of fraud after 2 years. And if for fraud, just two things have to prove: material non-disclosure and concealment, which was an active concealment, willful non-disclosure. Now, post that, a lot of insurance company, they now do a complete screening of all the policies beyond XY limit, depending on the policy they may adopt. So, even the insurance policies have been issued in a wrong manner. There's a screening which is done, and now there's a fraud database also being developed amongst insurance companies. There's a lot of exchange of information happened between the insurance, reinsurers, and try to reduce these kinds of fraudulent practices. So a lot of proactive assessment also happening now, so that these kinds of incidents do not get repeated. As you rightly said, yes, for the sales pressure to target, and also Sanjay ji mentioned where there are a group of fraud people who work together and try to corner the money of the genuine people. So very important to distinguish between fraudsters versus somebody genuinely made a mistake, or somebody who has individual person who has tried to make a non-disclosure versus fraud. So it is the fraudulent people who becomes more critical, because they try to siphon off the money by paying very little amount of premium, and they are frauds. Of course, another topic in itself to discuss, and there are many ways. But to answer your question, yes, there are cross checks and balances, especially 2014, where companies have implemented, which they do a complete screening of the insurance policies, etc., etc. And within 3 years, if any informations are given, they are, called in questions or cancelled, and premiums are forfeited or refunded depending on the action.
What Amberji was saying, very correct. I think I totally agree with him, because it is, it is very easy, by paying a insurance. Let's say if a person takes an accidental insurance, and in accidental insurance, not much of the checking is done. You can today online also take an insurance, accidental insurance, and the premium is so less, and the amount involved is so high. Within a friction of this management, if I may use the correct word, they can get a huge money. So it's such an easy way of getting money. So a lot of criminals, thieves, dacoits, I tell them, they take our public money. It is a public money which goes in it. Now, one last thing I want to ask you, which is, so many people are asking, your slides were so good. Amrik Singh Virk says that we want to have access to these, because we wanted to see these documents. So we would request,
no problem. I will. You can circulate it. I'll upload on my.
You please send it across to me. I will forward to these people.
Absolutely no issue.
Thank you very much, Amberji.
Always, all my presentations which I make are there on my LinkedIn.
Great.
So people,
that
anybody.
That would be great. I mean, we all will join you.
Yes. Absolutely no issues at all.
And anyways, this entire event would also go into YouTube, where all these things are there, very handy. So there are many other questions. I think the time permits for less.
I think we had a 1 hour session and it's almost not 2 hours.
Yeah, we are going to touch. Karthik, are you there?
Now, if there are 1 or 2 questions, maybe we can take it if it is permitted. Otherwise, we can.
Do you have the question? Any? Yeah, let me check.
If any, then otherwise.
Question. Can a person still claim life insurance after not paying his premium amount when his grace period has ended and there's no revival done yet? He's been paying his premium for a few months.
Nearby, Karthik is saying, Karthik, you can open your camera also. He is asking is that can do the claim?
So your policy condition will have those information up to which period you can revive the policy. Normally 30-day grace period is there, as I mentioned. After 30 days also you can pay the premium and you have to pay with interest. Normally what happened, up to 180 days you can pay the premium with interest, and after 180 days you have to go for a revival of a policy through certificate of insurability, meaning thereby at the discretion of the insurance company, they can also revive the policy. In that point of time, they will also ask you to go for a medical test once again. And if everything found okay, you can revive the policy after 180 days also, which is called as revival of the policy. Normally, most of the policies would have a 2-year limitation within you which revive the policy. Most of the traditional policies will have that kind of concept that within 2 years you can revive the policy, and after that it goes the money, whatever some surrender value that money will create, or fund value, that will go into discontinuation fund, and whatever the value has got it, then you can withdraw that money.
One question came from Jyoti Prakash Datta. Sir, if an insured person was diagnosed with a disease which was cured before taking the insurance policy, whether the insured is duty bound to disclose such prior disease, can reputation be made on this ground?
So again, going back to the same principle of utmost good faith, you must disclose. And most of the insurance company have a standard question: have you ever got diagnosed with any disease? Are you under treatment of any disease in last 5 years? Some of the insurance companies have 5 years, some have 3 years, but standard practice is 5 years. So
Yes.
even if you have been diagnosed with some disease and you got later cured, which is within 5-year period, you must disclose, because let insurance company take a call, because there are certain types of diseases which are a possibility of reoccurrence also, and it all depends on product to product. Some products may have that kind of exemptions, because I mentioned again reinsurance, because all these decisions are taken by the insurance company in consultation of the reinsurance.
Yes.
So they will have a policy of underwriting, they have a policy of reinsurance, and they can decide whether policy can be given or not. So better for you to give a disclosure to avoid any ground of reputation by the insurance company.
And as
Again,
a thumb rule,
yeah.
I'm so sorry. As a thumb rule, it is the prerogative of the insurance company, not you. By merely applying, by paying the check, you are not eligible for insurance. It is the prerogative. You are making a proposal. It is their prerogative whether they give you the policy or not. If they are not satisfied, they find that yes, there is some problem is there, some already existing disease or something. It is totally their own will. So they have their team who verify, they check whether it is this person should be insured, it is an insurable application or not. So I think
we can wind up now.
Wind it up. I would request Karthik, who's from Bombay only. He has joined from Bombay. Karthik would give a vote of thanks to you, sir.
Thank you, sir.
Good evening to one and all present here. My name is Karthik, and I'm delighted to be delivering this vote of thanks on behalf of BSK Legal. So, taking this opportunity, I would first like to thank Mr. Amber Gupta for taking out his time and imparting with us his thoroughly detailed views and thoughts on his life insurance sector, and enlightening us with his knowledge, which we will judiciously use in our future endeavors with insurance. Thanks to you, sir, to join our webinar and sharing it with us your legal expertise in this matter, and not only making this webinar a success, but also leaving with us your wise words and a food for thought. I would also like to extend my gratitude to our mentor and a well-known advocate, Mr. Sanjay K Chadha, for organizing this wonderful webinar and inviting Mr. Amber Gupta, giving us all this amazing opportunity to learn about the legal jurisprudence and frauds in the insurance sector, and also for sharing with us your knowledge, Mr. Sanjay sir, regarding this matter. Sanjay K Chadha sir, along with BSK Legal, have been taking incredible strides in spreading legal awareness among the law students and common people alike on his various social media platforms. Thank you once again, Sanjay sir and BSK Legal team, for your continuous support in helping us. We all are most grateful. Lastly, I would also like to thank my fellow mates, the audience members, and all our media partners who attended this webinar and helped make this great into a successful one. I'm sure everyone learned a lot more than we know before this webinar. Thank you all for having us. Thank you.
Thank you, Karthik.
Thank you, sir.
And
Thank you
Akanksha, I would like you to, once again come. And we are really grateful to her. She's one of our pillars. Manish is always there. Yogen is there. These people are the backbone, I must say. They are very brilliant students. Amber sir, I wanted to tell you. And I myself want to see Bhumika and Akanksha both becoming judges. That's what I have told them, and they are working on it. And once again, sir, it is really delightful. Meeting you itself is always, I have been a big, fan of yours. The way you conduct the things in your organization, I've seen it, from where you have reached, the way you have managed, the way you have obtained ISO 2000, whatever 9 or what, that shows that if you think that I think you have taken over from a different portfolio to this. And then now you have become, everybody in the country knows, the insurance people know who is Amber Gupta. So that's great. That shows your hard work, that shows your interest, that shows your, passion about the subject. Manish is there. Manish is also a dynamic, budding lawyer. He has also come. So these are the teammates.
Thank you for your kind words, sir, and always looking for your guidance. Always learned a lot from you in our discussions, deliberations, and so many arguments that we keep having on these matters. So thank you very much. Thank you BSK team for giving the opportunity to be here and sharing my limited knowledge, whatever I have, with their large audience. So it was always a great pleasure to be there on this session.
Thank you.
sir.
Thank you.